to the binary era. Today, we're going to review the European Commission's latest DMA specification proceeding directed at setting out the implementation measures that Google must comply under Article 611. The provision compels gatekeepers that have been designated for their online search engines, so Google Search, to provide third-party undertakings catering to online search engines at their own request with access on brand terms to ranking, query, click, and view data. The provision seeks to restore contestability in the search engine market by compelling the gatekeeper to disclose data on how queries work and how consumers interact with them. In general, search engines work around two types of queries, short-tail and long-tail queries. Short-tail queries are those involving one or two words and related to broad and general searches, which drive high traffic but low conversions. Long-tail queries are specific, targeting niche and high-intent searches that result in higher conversions. Search engine competitors can more or less anticipate what short-tail queries they should prepare for, but it is much harder for them to anticipate long-tail queries, which are the main driver of the success of their services. The gap in the access to data entails that competitors to Google Search can perform equivalent functions to a limited extent concerning short-tail queries, but they cannot function as accurately for long-tail queries. Google holds a massive advantage, being roughly 93% of unique search phrases compared to just 4.8% seen only by Bing. This discrepancy means the gatekeepers has a superior ability to understand and deliver results for highly specific early search or new queries, whereas smaller search engines may struggle to provide relevant results for these long-tail searches. Article 6.3 intends to eliminate default settings that operate in favor of Google's own search engine. A screen is shown to the user to select alternative search engines. 6.11 acts as the other side of the coin. For consumers to select an alternative search engine and maintain the choice when using the service, those alternative services must provide equivalent functionality. The EU legislature believes that a part of the competitive advantage carved out in the form of Google's superdominance in search precisely comes from disparities. Therefore, Article 6.11 provides quite a striking solution. Google is compelled to provide access to, first, data on the positioning of content stemming from the algorithm's ranking, analysis, and display on the results page. Second, the exact series of words that users type into search engines when they want information. Third, the records showing which search results users click after entering a query. And finally, the information that the search engines collect, store, and process to understand the web, the ranking of websites, and to personalize results for users, from the index of crawled websites to the personal search history and structured metadata that help crawlers interpret consent. The DMA's obligation is not particularly new to regulators. It is an idea that competition authorities and courts have been considering for a while now. In September 2025, a US federal judge issued a ruling in the DOJ antitrust case against Google, ordering the company to share specific search index and user interaction data with qualified competitors, including raw user interaction data that associates queries and results with user interactions, such as clicks. The European Commission's ask is not too out of the blue then, but it still has met some friction, precisely due to the provision's content. So let's go back to it. Article 6.11 of the DMA declares that any such query, click, and view data that constitutes personal data shall be anonymized. What does that mean in practice? Since consumers do not consent to the sharing of data with competitors, the gatekeeper must ensure that all data that may identify a user must be anonymized. The privacy utility trade-off comes into play here. If the gatekeeper anonymizes data to an extent where no user identity can be traced, then the utility of that same data will be drastically reduced. Even if data is made available to search engine providers, it will not fundamentally impact the way in which they can tweak and dramatically improve their services. As a matter of fact, in the US, Privacy experts already discussed that Google must find the perfect spot where privacy and utility are sufficiently enhanced so that one dimension does not cancel out the other one. This brings us to Google's current compliance approach toward the application of Article 611. By 2024, it developed a new European search dataset licensing program where third-party providers can obtain Google search data on more than 1 billion distinct queries across all 30 EA countries. To comply with the anonymization requirement, Google built a dataset based on frequency thresholding. In practice, competitors already voiced their concern about the fact that such robust privacy protections deemed most of the data completely useless because they could only reach short-tail queries. Aside from that, Google established a licensing program to comply with the provision, where third-party search engine providers subject to a contract would be charged a fee in exchange for the access to the data. Depending on their financial situation, the EEA countries they wanted to extract data from, and the percentage of the dataset that they wanted to access. You can see a simulation of the prices that Google set out in the 2024 compliance workshop. Access was to be rendered under Article 611 according to front terms. So there's a first indication that Google's representation of compliance might not align with what the European Commission had originally planned. At the moment of recording this episode, no third-party provider has sought to apply for licensing. Against this background, the European Commission has recently launched a specification proceeding against Google. I'll also link a video on the show notes that I recorded on Apple's specification proceeding. According to the enforcer, the proceedings against Google will focus on, first, the scope of data, the anonymization methods, the conditions of access, and the potential eligibility of AI chatbot providers to access data. Building on the challenges posed by Article 611 and the questions that the European Commission has recently opened when triggering its specification proceeding, I am going now to discuss this issue further with someone who has recently published on the legal principles surrounding the application of Article 611 of the DMA, Jasper van den Boom. He's an assistant professor in EU competition law at Leiden University, and his research focuses on how competition law and regulation should govern digital ecosystems. So on that note, you should also definitely check out his recent book, Regulating Competition in the Digital Networking Industry. That's a good title, published by Cambridge University Press. So welcome to the Agora, Jasper.
Thank you so much for having me. I'm really excited to talk about this article and to join the podcast.
You have also researched the topic in depth, and we have already a paper of yours where you outline all of the principles of Article 611. I wanted first to ask you to flesh out in 2 sentences how consumers interact with search engines.
Very shortly, consumers really use search engines as their entryway into the internet. This is not new. We rarely look up specific pages, but we use search engines for everything from looking up professional information on hobbies, booking trips, or planning days. And usually it was the case that the search engine links you through to the pages where you actually find that information. I think now for consumers, AI and generally the introduction of more information on these pages is really changing the experience, because instead of going forward, you usually already stop on the page itself.
Thank you for that, especially because I think that many of us interact with search engines but do not quite know how consumers react to them. The main tenets of the European Commission's specification proceedings is that of establishing a set of agreed conditions of access to the ranking, query, click, and view data held now by Google Search. In your paper, you also navigate this topic by touching upon different aspects, notably questions of non-discrimination, reasonableness, and pricing. I was wondering whether you could walk us through how you think that Article 611 should be implemented by Google Search.
I really focus on that question, and I think the takeaways from my article can be divided into 2 topics. So what do we want substantively and what do we want procedurally? Where we are now in terms of procedure is that Google has one horizontal access scheme, that's one size fits all, that says, okay, pay €3 per 1,000 queries. Google then selects those queries, how they are anonymized, how they are presented. And as a result, much of this information is actually useless to those that seek access, either because it concerns very general queries or irrelevant queries, or they've been overly anonymized. In terms of procedure, I understand friend obligations as to require a framework for negotiations. Access seekers should be able to go to Google and tell them, this is the information that I want, this is how I want it, this level of anonymization is acceptable in my view. And then Google can assess, is this request feasible? Is the anonymization sufficient? And make a counter offer. And friend comes into play to make sure that that offer is reasonable. In terms of substance, friend means fair, reasonable, and non-discriminatory. Fairness has a special meaning in the DMA. It's intertwined with contestability. Conditions are only fair if they effectively contribute to allowing these search engine providers or access seekers to develop their own services. In terms of being fair in the imbalance of power, gatekeepers hold the inherent imbalance of power over their business users, and the restrictions on the pricing should reflect that imbalance. When we talk about the price for access, fairness means that as a rule, access to data is given free of charge, and friend is the exception to this free of charge principle. Secondly, that the price cannot reflect the incumbency of the gatekeeper and externalities of these markets, but it should mimic competitive prices. Google mentioned in their compliance report that they looked at other pricing access regimes as a benchmark. And then I wonder, who could possibly offer something similar to Google in terms of search data? Finally, the price should also reflect how great the imbalance of power between the specific parties is. So for a smaller access seeker, it should be lower. And for a larger access seeker at the size of the business, it can be higher. It makes sense that Google can charge more to Microsoft than to Ecosia. I think that having this system where the business users of Google are in the lead makes a lot more sense than giving Google all the cards in determining the access policy.
3 points on that. The first one is Google is not pursuing the negotiation path at all now. So it's just saying and imposing these general rules and saying these apply to everyone and you take it or you leave it. And I was wondering within this idea of negotiation case by case, whether you would have those negotiations fenced in the sense that will access seekers have visibility on what is acceptable for the other agents, or do you see that as a closed system of one-on-one negotiations? On the price benchmarking, I guess that Google used some benchmarks and some pricing thresholds deriving from data brokers, which can be quite useful in this sense, since there's no replicability to this usage of data. Maybe you can give me a few thoughts on that.
On the pricing, I think it's kind of similar to the cellophane fallacy. When the price is already inflated because you have a monopolist, and then you use the monopoly price as a benchmark, then you end up with an unfair price. We need to critically reflect on the pricing strategy before we accept any benchmarks offered by the gatekeeper itself. And then in terms of the generalizing the access regime, in the article, I make a lot of comparisons with exactly this bottom-up progressive approach used in Article 6.7, where you do have a bilateral negotiation, but if you send a request, they give you a technical reference. This is how we can technically enable your request to happen. On the basis of the technical reference, makes a strategy to provide interoperability, and then ultimately it offers an interoperability tool. According to Article 6.7, those tools, those interoperability tools, have to be as general as possible, and they have to facilitate any type of use case. That's probably difficult for data access, but the idea of the technical references is very useful. So somebody makes a request, they say, I want this type of data, and I want this level of anonymization. Then Google publishes their response, but you can say, these are the categories of data that we share, and these are the anonymization techniques we've used. Once they've accepted that request by one party, they are bound to accept that request by other parties. If that request is similar in terms of anonymization techniques or categories, it binds them. I think this is a very useful way to combine the idea of having closed-door bilateral negotiations, but also providing enough information and technical resources to make it broadly available.
You would have the technical reference before the access is sought or after, because I'm thinking,
From my
for instance,
understanding,
I'm thinking of the parallel with Article 7 and how interoperabilities work in there, and there the European Commission did, and the provision compels WhatsApp to provide this technical reference offer that all access seekers can access, and then they can negotiate one-on-one.
The technical reference provides a sort of benchmark of what can we supply under which conditions. And I think it's useful to have those technical references available so that we know for future access seekers, this is what can be requested and this is what others have already requested. And then the outcome of the negotiations. The next access seeker will indeed be able to look at the technical reference. Is this exactly what we need, or do we want to make adjustments? If they request adjustments, there is a new technical reference. And like this, it can build on the basis of these technical references.
We must expect that that these requests happen over time, because search engines and the search engine data that is correlated with this service really does not have much value if it's outdated. So maybe that's the way to go forward. And pivoting a bit to another aspect of the proceedings that really surprised me, the European Commission announced in this press release that it would assess whether AI chat providers should be eligible to access the data. And this is something you already considered in your paper, although not in detail. I was wondering whether you had any initial thoughts on that. To me, two salient questions really come to mind. First, what chatbot providers is the enforcer referring to? Any chatbot provider, or any one of them with a clear presence in the search engine sphere, or any type of economic operator that can act as a substitute of search? And the second question would be whether these AI chatbot providers should access the whole range of data within Google's dataset, or only the ranking, click, query, and view data concerning, for instance, the user's interaction with AI overviews and AI mode, because that's the sphere and where they would compete. So I wanted to hear your thoughts on that.
I think this is a very important question, not necessarily with an easy answer. And like you said, I've touched on it lightly. I'm sure there will be very interesting follow-up research, maybe by you or by me, we will see. The way I understand Article 611 is that it's reciprocal. So a search engine provider has to provide the data, but it can also only be sought by a potential or actual search engine provider. If I receive data under this provision, I'm also binding myself in a way to develop a search engine. I accept that I will be bound if I'm designated in the future. And I think that this can help us to also develop a bottom-up approach here, where we say who actually requests data, how do they incorporate this data into their services, and what does that mean for a search element? Then we can distinguish between what is a search-based chatbot and what is not. OpenAI has launched ChatGPT Search. Now, that's a search engine, but other large language models can fulfill search tasks, but are not necessarily aimed at that. In terms of the scope of access to the data, whether they should get access to the full range of data or only this ranking, click, and query data, I think that the scope is quite clearly stated in the provision. But the question is, how do we understand the data boundaries? If we imagine somebody is searching what is the most popular pop star in the world, and then we have a range of selections like Taylor Swift and Ed Sheeran, you can become more abstract in the link between what has been searched and what is the answer. AI overviews actually use a lot of that similar information. They also use this click and query data to answer these types of questions. Because if I ask ChatGPT, who is the most popular pop star in the world, what metrics do they base it on? Most likely search traffic, or people who are interested in actually learning something, or people, when you say who is the most popular pop star, click that link and think, now my search is over, this is the one. Where does the boundary of click and query data end? Let's say there is a huge spike in the meaning of a certain concept. So for instance, what is Brexit? Once we know when that has been searched, and by people in which geography, and even by the demographics, we can understand a bit more. How do people experience and conceptualize the world? And I think that is actually where the AI overview sets itself apart from search. It's that it tries to contextualize information as well. There is the boundary of query, click, and results data, but it should be up to the access seeker to explore what the boundaries are and request certain types of information. And then Google should be bound to provide this data, only refusing it if they can justify a refusal. Now, in terms of the use of data, I think it is interesting to note that it does not say in the provision that you also have to exclusively use the data that you found for the development of a search engine. So you have to be a competing search engine provider, then you can get this data, but you can use it for any type of tool that you want. From my perspective, it should be interpreted broadly so that especially disruptive future technologies also get a chance to make use of this provision and to contest search as we know it today.
As you were speaking, I was also thinking about types of queries, for instance, of when was Taylor Swift born, and then you won't have any click. You will only have view data. The scope of data categories that are really necessary for these AI chatbot providers are only view and query data, as opposed to the actual clicks, because now we are seeing a great evolution of search engine, which is not only pivoting towards AI, but actually that clicks are less popular with consumers and users, and they aren't really incentivized to click on an additional link to read the same information. Going back to the differences and similarities with Apple's Article 6.7 specification proceedings, you argue that the base of effective compliance with 6.11 derived from these negotiations taking place between the gatekeeper and access seeker. I reasonably disagree with you in your paper, in the sense that you say that the European Commission discarded request-based processes. I think it's a bit more tempered down. The European Commission did not say you cannot use request-based processes. They are quote unquote bad, but we can fix them and we can apply legal principles on top to not replace the rationale that you used. I was wondering whether you think that something similar may happen in Article 6.11. Maybe we won't have a shift towards this negotiation 101, but we might have these legal principles that we were outlining at the start on top of them, of the general approach, and maybe we have a middle way solution.
Okay, that's a fair critique. I don't mean that horizontal access regimes are never an option. In Article 6.7, the starting point was very different. So the Commission considered, do we understand a horizontal access regime as that Apple basically has to make a lot of libraries and protocols totally public, and have a sort of open source plug and play approach where Apple has to throw open their ecosystem and anybody who wants to jump in can jump in. And they discarded that because they said, we're going to have a more targeted approach that is more bottom up and progressive. Now, it is true that Apple did have a horizontal access seeking portal, and the Commission said that portal does not suffice. But indeed, I have overstated if I said that there can be no horizontal access regime. There probably can be if it is effectively compliant. What I wonder about with Article 6.11, and where I'm skeptical of any horizontal access regime, is that you end up with either what Google has done, which is that the gatekeeper gets a lot of power in determining the access conditions, or you have a horizontal access regime like Apple, and you say, okay, you have to make a data repository, you can search, and then anything that you extract, you pay for. Because the idea of query results and ranking data is so broad that to impose such an obligation would also be disproportional. This bottom-up approach allows for a process of discovery that, especially in an area where access to this type of data is new, the pricing has to be redetermined. It is a very useful way to explore what exactly do business users want, what do they want to pay for it, what are the caveats that we haven't thought about, because it can also be that access seekers search for a type of data, for instance, for AI overviews or AI search, that we actually hadn't considered. And then it can give us great leads to think maybe the DMA needs to be adjusted in one way or another.
Thank you so much, Jasper, for all of your insights. And we really look forward to more research on this topic. So thank you so much for joining us here in the Agora.
Thanks so much for having me. It's a pleasure.